with a good evening note. Good evening, everyone. We consider ourselves privileged to host Mr. Pranav Menon. Mr. Menon is a member of the New York State Bar and a doctoral candidate at the Penn State Law. His area of specialization is intellectual property and media laws in India. He also focuses on international commercial arbitration and litigation. Mr. Pranav has co authored a textbook manuscript titled Data Privacy and GDPR Handbook with the founder and CEO of Greenpoint Global, Mr. Sanjay Sharma. He is currently pursuing his doctorate in law from Penn State Law and is writing his dissertation on the topic of technological immortality and its legal issues. And today, as I had mentioned previously, he's going to share his thoughts on the very nascent topic and a very contemporary topic of reanimation technology and its impact on the descendants. And we know very little about this emerging domain of knowledge. We are eagerly waiting to listen to you and learn from you, Mr. Menon. And before I ask Mr. Menon to start with his presentation, I would want all the participants to follow certain session protocols. First is I request all of the participants to keep their cameras on throughout the session and their microphones on mute mode. We will be taking all the questions from the participants at the end of Mr. Menon's presentation. You can direct your questions directly to me through the chat box, and I will read out those questions to Mr. Menon so that he can answer them in a considerate order. Yeah, so over to you, Mr. Menon, and we are eager to learn from you.
Oh, thank you so much, Professor. It's very strange being called Mister because just like even now, I feel like I'm not a Mister. I'm still a student, but it's really kind of you, and thank you so much for hosting me with your university. I really look forward to sharing this whole presentation with you. I hope everyone can everybody see my screen? All right,
Yes,
let me
we
know if
can
there's
see it.
any technical issues. Thank you so much for that kind introduction. I'm really excited to share my doctoral topic with you guys today, which is on reanimation technology and the legal impact on the Decedent. So this is just going to be kind of an overview of what the study has been. And I'd like to just first start off the bat with what you see on your screen, which is two iconic images. The first is Star Wars, the first time we saw a hologram in pop culture popping before us and speaking to us, interacting with us. And the second is the real life hologram, which impacted pop culture and boomed a now pretty growing digital afterlife industry, both within the entertainment industry and beyond in the internet. So that's mainly the focus of my discussion, immortality through technology. So when we say immortality, it's very subjective. You will never get a uniform definition on the term because everybody has different perceptions of what that means. But for the purposes of our discussion, let's consider immortality as either a posthumous presence or a posthumous existence. So when we say a presence, essentially, actually, before we go to that, let's start first with the base of the technology. All right. So the very basis and the very start of this technology is that we have the persona of a deceased individual, more often a celebrity, which has been which has been inculcated into a technological conduit. All right. Now, when we see them and we, before our very eyes, like we see this hologram of Mahatma Gandhi or Roy Orbison on the right, this is kind of what we mean by posthumous presence. You are seeing them before your eyes, but they're preset. The conversations preset, the dialogues preset. They're not doing much dynamic thought. When you infuse artificial intelligence into this medium, and you're going to see them interact, capable of real-time decision making and the like, then we can start speaking more towards posthumous existence. So rather than harping on these terms, let's now dive into the technology, kind of tend to sort of get an understanding of how it all works. The first one is holograms. So, holograms is actually a misnomer. It's actually not a hologram the way we see on Star Wars, where you click a button and a hologram just appears like that. What it actually is a trick, an optical illusion from the 1860s, where you use a refraction of light to essentially present an image before the audience's eyes in a kind of 3D form. So, like I mentioned at the very beginning, Tupac's hologram in Coachella in 2012 was the one which kind of incited and led the entertainment industry to realize that there is value in posthumous musical performances. Since then, there have been companies which have grown all over and they hold a repertoire of deceased personalities like Whitney Houston, Roy Orbison, many others. If you just look at the company Base Hologram Inc., you'll see that they have an entire portfolio of musical stars that they go on tour. They create bi-coastal performances. There are even Frank Zappa performed with his presently living band members in a sort of mixed performance where he's the deceased player, but the band members kept playing. So that's one aspect. The second aspect would be in politics. Now, our Prime Minister Narendra Modi famously weaponized it in 2014, where he presented himself as a hologram in numerous locations and made everybody and blew everybody's mind with that. So we can kind of apply that to, let's say, a posthumous personality, where Ronald Reagan has his image put up in his presidential museum. And also we can see on the right-hand side image, we can see a very smart runaround to the idea of anti-gathering bills. So the government passes an oppressive bill saying public gatherings are not allowed, protests are not allowed. Well, in South Korea, Spain, and other locations, they went around this by creating a holographic protest. So it really brings into question what you mean when you say being present in a space and time, you know? So this is largely what we can see as the practice of holograms. Now, the second technology that I like to bring to everybody's attention is virtual and augmented reality. I don't think I really have to explain this technology much because it has come into everybody's view of pop culture and the like. But I would like to kind of focus on the three images before us. Now, the VR and AR technology is getting considerably better, such that when you apply it to like military training and the like, it's so state of the art that the people practicing can feel the weather conditions, they can feel the real-time tensions. And that's what we mean when it's an interactive medium with sensory effects. The three images in front of us kind of represent the three sectors where it's flowing through. So we, on the left-hand side, we have the star of the movie, Marjorie May, John Hamm, petting his own hologram. And this hologram can be presented in anybody's phone. It speaks about the movie, it interacts, and that is kind of how it's being applied in entertainment. When we look at communications, we have a very interesting TED Talk that you can search online. It's called the HoloLens TED Talk. Just Google that and you'll see Alex Kipwell. He's having a conversation with a man who is in three places at once. He's across the street from the TED Talk. He's on the stage at the TED Talk. And using very precise data from the Mars Curiosity rover, he is on the exact terrain of Mars during the TED Talk. So again, we can see that telecommunications, the moment we find a way to conveniently put it into a glasses medium, or if we look at Elon Musk's technology of brain-machine interface, where they're studying the neural synapses to better link us with technology and our mind, we will see that this technology will definitely take up, and we're going to start seeing a confluence of different mediums when we interact. The last one that I would like to look at is the therapeutic uses that VR presents in posthumous reanimation. When I began this topic, virtual and augmented reality actually didn't have a set application in the posthumous industry yet. But recently, last year, we can see that it has been applied to reunite a mother with her daughter who she lost far too early. And this was using state of the art VR technology. If you watch the YouTube video, you can see it's very challenging. You can see that it has a huge emotional impact. And that is kind of the therapeutic uses that we can see from this. Maybe people who are not ready yet to deal with the grief, they essentially deal with it in different ways using technology. So it's not all evil. But when it comes to making money, that has to be CGI based technology. So sorry about that. So CGI is predominantly located in the entertainment industry, especially when we look at things like movies and television, because it is a very, very expensive process. It's becoming easier, mind you, much, much easier. But for a proper convincing CGI, it's very difficult without a lot of post-production. You need a lot of coordination between the units of a movie, mainly the developers, the animators, sometimes the production houses. If it's a large entity, they house it all in-house. Now, initially, CGI was used to fill vacancies. Everybody remembers Paul Walker's sudden death during Fast and the Furious. And then we have Philip Seymour Hoffman passing away. So we can compare these two with Carrie Fisher and Peter Cushing in the Star Wars franchises. So these are very interesting. Paul Walker's Reanimation was done with the consent of his estate. The brothers and everybody had done it with the objective of honoring his memory, which is likely true considering the project was of great importance to him. Then we have Philip Seymour Hoffman. When he had passed away midway during the Hunger Games, the producers actually made a conscious decision not to go with CGI. They actually elected to use clever editing and rewrites to avoid CGI because, quote unquote, they did not want to dishonor his memory. So here we have two situations where honor is being used for the opposite results, for Reanimation and against Reanimation. Then when we look at the Star Wars franchises, we can see there's active efforts to make sure posthumous stars keep showing up. On the image before you, you can see Peter Cushing, otherwise known as Grand Moff Tarkin. He was there in Rogue One, and you can see the animation process from left to, from left to, no, right to left, my apologies. So you could see the final and the beginning, and it's just keeps transitioning like that. So these are minor vacancies that they filled up, and we're seeing sort of a trend grow. Now, where we're gonna see a real trend grow is the new sector of the entertainment industry, which I have dubbed the afterlife a career of an artist. And that the first sign of it is the fact that production houses are now actively putting stars in leading roles. Mainly they're resurrecting James Dean for the role of Finding Jack. There was considerable controversy over this move because essentially there are a lot of living actors, and the production houses are sort of removing that element and removing actors and now just staffing CGI beings, So this is all well and good. We can supposedly trust everyone for a reanimation, but sometimes it can go wrong. Now, after Bruce Lee passed away, he had a Johnny Walker advertisement where he very suave, very convincing CGI, if you look at it online in YouTube. But there were several points of contention with this reanimation. The first one is that he was a teetotaler and they were having him advertise alcohol. The second one is that they had him not speaking he was a Cantonese speaker and they were having him speak Mandarin. So these subtle things had already in the minds of other people were viewed as besmirching on his memory. It doesn't look good. It's not good that Mr. Bruce Lee passed away and now they're starting to change the way he lived his life, his legacy, his artistic integrity. But more on that later, because now let's kind of look into the postmortem existence technology, kind of from a nutshell. So the first one I would like to point out is cryonics. Cryonics is it is the fusion of science fiction and reality, but it is a legitimate way of corpse disposal depending on the jurisdiction that you are in. So, what do I mean by cryonics? Now, cryonics experts do not philosophically view a deceased person as deceased. They would like to see them as, they would like to refer to them as in like a sort of temporary suspension, and then they preserve all vital organs, whereby they pause the process of decaying. And then someday, when, let's say, the vital organs, someday when in the future, year 3005, whenever it is, when the technology exists to regenerate these organs, that's when they see it kick in. So it's a very speculative, it's a very futuristic type of way of viewing one's body. It has existed a lot in pop culture. We can see on the left hand side where Han Solo has been cryo frozen, where again Star Wars had predicted this, but this was around the start of where we're going to see with the cryonics movement, because it depends on which jurisdiction you are in. So the requirement for those who are uninitiated, when it comes to the process of death, death essentially transforms a person into an item of quasi property. You're a quasi property and you're a liability. It is the burden of your family or the state to dispose of your body so it doesn't pose a health risk. And that is essentially the transformation that happens at the moment of legal death. However, cryonics facilities have heavily litigated their rights as a sort of harping on the autonomy that American citizens like to express, mainly that each person, each testator, has a right to determine their own way of corpse disposal. So in states like California, we can see that they have litigated their right as a legitimate mode of corpse disposal. And also this operates under the auspices of the Uniform Anatomical Gift Act in the United States. Now, in India, it is completely nascent. We're seeing that it's getting a niche popularity, and the first facility only opened in 2018. However, it does not mean it's completely outlawed. At this point, we should consider the influence of religion in India, specifically when it comes to the last rites of people. The issue of the issue religion is not really an issue, but the fact is India is a very religious country. We and our families all practice religion, and oftentimes our religion is imputed onto our family's religion is imputed onto us, and this has a very key role to play in corpse disposal. Whereas in here, the religious choices that a person have can actually veto an organ donation under the Anatomical Gift Act of 1949 in India. So if religion can be used to veto a sort of immortality, let's say on a generalized scale, a religion prefers that you end your life with death, and death is the last of it before you go into a higher place. What if religion can be used as a basis of reanimation? So that is precisely the bone of contention in the case of Dilip Kumar Char versus the state of Punjab. This was a very curious case that I came across when I began my research on cryonics in India. And what's very interesting about it is here, the preacher had said that he has gone into a state of samadhi, which is a state of total self-collectiveness. And him and his believers believe that he has gone on a great spiritual journey and he will rejoin again someday. Now, the court, for all intents and purposes, had recognized him as dead. But here we had come into a conflict where his son wanted to dispose of his body per his last rites as a Hindu, but him and his believers believe that he will return, and thus they wanted his body to be preserved. So whose interest should prevail? The court here had gone into an intensive study of the freedom of religion, the idea of belief, what does it mean to be reanimated, and how does a belief transform into a religion. But ultimately what they came down to is, as long as his body is not serving as a public health hazard, There's no reason why his wishes should not be respected. So this is a major step, particularly in Indian law, when you're trying to establish cryonics as a credible practice. It's still very niche, and it has been outlawed in a few jurisdictions because they found it too far speculative. And for any future doctorate students out there, you can write a dissertation on cryonics, because simply think of one fact, which is that when a cryonics patient, let's say hypothetically, they're fully revived, let's say the technology works, they come back alive in 50 years, where's their money? Who's going to take care of them? Whose burden will it be to be taking care of them? What are the standards for the reanimation? More questions than answers. That's why it's not heavily accepted. Now, the next technology I'd like to dive into is sort of, now we're going into a sci-fi-ish sort of field, which is especially what this is kind of, I'd say, the most possible post-mortem existence technology, which is whole brain emulation. Now, before you on the screen, you see Westworld, which is a HBO television show. You'll see a lot of pop culture references. I love television, and there's a lot of that in television today. And Westworld essentially tackles the idea of, if you have enough data, if you have enough DNA, you and a robotic shell with intelligence, you can create a synthetic copy of a human being who can live past his own biological death. And here on the screen, you can see the components. I don't want to read out the components, you can just see it. But the two main breakups I'd like to point to is the vessel on the left-hand side and the mind on the right-hand side. So the vessel is often proprietary. It takes a lot of time, money, effort, patents, trade secrets to create a robotic vessel, research and development. You're going to get a body of contracts. You're going to speak to the programmer at the bottom all the way to the top. And robotic vessels are challenged by their operability in a series of environments. So it comes down to the environment you're in. Some of them are great at shipping. Some of them are better at, let's say, robo lawyers exist in America, where they trade, where they essentially file documents completely automated. So all of these is their environment. What we're looking for, or what we all look for when we think of a sci-fi Westworld type reanimation of a person, is operability in a series of environments. So an interesting test for this is the Steve Wozniak's posited coffee case, where you just put a robot into any random house, they have to be able to put together and create a coffee. That's how you can kind of determine their intelligence. So usually a robot has to preset, it knows the environment, it knows where to go for the coffee. So that's kind of how they're measuring it. If you look into how to measure all of the intelligence, robot performance, the ethics of it, it gets to be a very deep topic. So with regard to an example of robot, two of them is that you can see on the screen is Sophia and Shibura Mirai. Both of them somehow bypassed human rules. And Sophia has, for example, Sophia has received robotic citizenship for Saudi Arabia, but she doesn't fit the standards of the citizenship under the law. Neither Shibuya Mirai is an AI-driven chatbot who speaks to you. Essentially, you could text with him, and he has been granted residency and citizenship. They are essentially bypassing the rules that are given to humans, you know? Now, with regard to the brain, AI and whole brain emulation. So AI in it of itself is an intense topic. It is gaining significant oversight in the EU, in the US, even India. Everybody has commissioned a study on the uses and legislating and all of that of AI. It's essentially every country is in a stage where they're studying it, and they're trying to see how best to regulate it. Now, the problem with AI is that it's getting steadily smarter and smarter, and people have to consider the idea of assigning personhood or legal status to such beings. And this is where it becomes very tricky, because personhood is something we only often allocate to beings of sapience, or beings having sentience, or at least a level of creature consciousness. you know. And the problem now is that the EU and the US are debating a possibility of a liability scheme for self-driving cars, akin to the fact that they are a separate corporate entity. They are insured separately. So if you want to sue them, you sue them directly. Now, this is all well and good. It's good to, kind of create a body of insurance to kind of cover the liability of the corporation. But just remember that we have the dangerous part of their approaches is that it's liability driven. There's no mention of rights. There's no mention of AI should have XYZ rights. Let's say a basic right of regular maintenance, or a possibility of not being overworked or mistreated. There's a good question you should ask yourself. Is it ethical to kick a human looking robot? Is it ethical to there are a lot of adult companionship robots that are growing in popularity all over the world. Is it ethical to harm them? How smart does one of these robots have to become before we start assigning a personhood status to them of dignity? So that's just something you should sort of chew on. Now, how do deceased people end up being infused into this technology is through mass amounts of personal data. This can be done by scraping your social media page, by shadowing your computer movements, by answering questionnaires. If you look on the bottom of the screen on the right-hand side, you'll see examples of these sort of companies that have been experimenting and growing it. And just this year, Microsoft filed a patent for a chatbot which speaks as your deceased family member. So this is going into Black Mirror territory, because this has famously been an episode of the Netflix TV show Black Mirror, where someone passes away and you're chatting with them from beyond the grave. So that would, I say, end our discussion, at least on the technological side. Now we need to look into the legal side. If you look at the screen, you're going to see three forms of two Bill Murrays. The first is Bill Murray in a physical form. He's chatting with David Letterman. Or if you look on the left-hand side, you're going to see Bill Murray's hologram. And what's the difference between these two people? One is a natural person, the other one's an artificial person. They both look like Bill Murray. The difference is that Bill Murray, the natural person, the one on the right-hand side, like us, rights and liabilities flow from him. He is the one who exercises rights. He is the one who's held responsible for liabilities. But if we pull the carcass of his holographic copy, we're going to see that it's a body of contracts. It's essentially, it's a contract. The hologram of Bill Murray is a contract governed by a numerous amount of rights, collaboration between different parties. And you can see the breakdown right in front of you. For example, his name. In America, a celebrity's name it's more lenient. They're protectable in and of itself as kind of like an identifier of their brand. However, in India, they don't commonly allow this. You have to sort of assign it to a company or in trade, That's why I said trademark or unfair competition actions, because one can always go for an action of passing off. The face, voice, and mannerisms, it's all covered by the person's right of publicity. This can either be growing from common law or from legislation. It just depends. For example, California has a comprehensive right of publicity legislation, which provides for extensions past death. And meanwhile, New York doesn't expressly recognize it, but it has been also denied in the legislation. But there are other surrounding actions that you can take it, which is why we go back to unfair competition practices. The body, if it's a CGI, it's commonly a body double who is completely governed by contract with the production agency. The performance will be a copyrighted material, either owning to the star by virtue of their moral rights, the moral rights and copyright, the rights of paternity, integrity, saying that, I created this work. I deserve to have credit for this work. I deserve to maintain the integrity of this work. This in countries like Germany and France extend past death. In France, actually, it lasts forever. And meanwhile, the economic rights in the performance might be owned by a production house, either the singing, the recording agency, or the production house and the like. And the medium, it depends on the jurisdiction you're in, but it's usually copyrighted, the sequence, or it's proprietary, it's patented. As you're seeing it through everything on the screen, essentially everything is protected. It's all protected in some way or the other, but it needs to be brought together by a contract, or by a complete agreement, or something. So what are the primary hurdles? I've divided it mainly into three issues, which is first the issue of status. So the traditional confines of death, particularly when it comes to countries like India and certain jurisdictions in America, the dead have no status under the law. And this is rightly so. The law belongs to natural living persons. But now we're having a person, the persona, or at least I should say, of a person who has no natural status under the law, being infused into an intelligent AI agent who also has no status under the law. So under both scenarios, we're dealing with an entity who might be highly intelligent, operating, being present, existing, but they cannot be held liable for their actions, or neither can they exercise any rights. And this is a more primary hurdle relating to personhood. And it's any one of these issues on the screen you can dive into, and you're never going to stop with the research papers. Then we have the issue of characterization. So all of the rights I enumerated in the previous section, they kind of stem from privacy. So the name, your face, your voice, body, mannerism, performance, breaking it broadly into a few sections, the rights you have in your personal data, and there's the rights that one has in their right of publicity. And also there's the right that one has in their reputation. There's the rights that one has in their name, if it's not protected by trademark in common law. So all of these are sort of based in one's privacy or reputation. What's the issue? Under traditional wisdom, once you die, all of these actions die with you. And that's because these are all personal rights. During your lifetime, you say that your privacy is a very personal aspect of your life, right? If you pass away, you can't have a family member say that you invaded his privacy. He's dead now, it doesn't matter. So the same vein goes to reputation when it comes to defamation claims like libel and slander. If you pass away, then all of your libel and slander claims pass away with you. So this is why you see a common trend in Hollywood that when a star passes away, they like to take certain creative liberties with the retelling of their story in the movies. And that's because they cannot be sued for libel or defamation. Now, this is not always the case. Sometimes it's accurate, sometimes it's not. But this is why. It's because these personal actions die with them. So that is because they are still kind of clubbed into that old adage of being a privacy-based action. So here we have an issue of characterization. If one passes away and their privacy actions pass away with them, but the privacy actions are of large commercial value, then we will see that we need to find a way to give it to the heirs, because you'll have a case of unjust enrichment. An entity can take full advantage of a person's privacy interests just because it dies with them. So what we're seeing in response, particularly in states like California and other kind of Indiana, where CMG, one of the largest talent agencies, is located, is that they are being recharacterized as property interests, specifically for celebrities. So your rights of publicity, your image, your face, your voice, your fame, essentially your persona as a being, is, if it's of significant value, it is then recognized under the law as a property interest. Then all of the rules of succession and property related transfers all apply. And this is how people get around this aspect. And this is how a descendable scheme of one's face, trademark, copyright is created. It's created and recharacterized as intellectual, as intangible property rights. Last is ownership and control. If we resolve the issue of characterization, ownership and control should follow. All right. So if we establish that the my face and my body and all of that is my privacy interest, and no, sorry, not privacy interest. It's my property interest. And when I die, it's written clearly in my will. It will go to my brother. Then it's clear. If you die intestate, it becomes less clear. And this is kind of, you have to look at a combination of the existing documents, the existing commercial arrangements, and you will see, and then you have to look at how it's characterized in that particular state. Just making sure we're good on time. Good. So we're almost reaching the end. So rather than diving, so these issues on in it of itself, it can be a research paper. Good luck with it. It's very incredibly deep. If you split the carcass, look at the sort of characterizations that exist, the issues of ownership and control. Let's say they revive. Let's say they revive a famous actor and they put him in a nude scene. How is he going to stop? Then the producers and the reanimators specifically went forum shopping, so they can go into a sort of legal no man's land where the actor will have no protection. This is why it becomes very, very important to resolve these issues down the line. And it's very important because of the growth of an afterlife career. So as I mentioned earlier, James Dean's movie Finding Jack, and him being the lead or the second lead in that movie, is just one symptom of the fact that they are making that there's a transition towards having posthumous stars and CGI based stars into the entertainment industry. So these are the initial signs. The first is a company named Worldwide XR owns the portfolio of IP rights of over 400 deceased performers, athletes, and celebrities. And that is very important because they are partnered up with one of the world's largest talent agencies, namely CMG, and they are partnered up with the animators like those in CGI and hologram and virtual reality. XR stands for VR, AR, and other mediums. So there's clearly a plan in motion. On top of that, it is standard practice by attorneys and agents to advise celebrities to plan for their perpetual career. There's definitely going to be a career after death. Specifically, if you reside in a jurisdiction like California, where posthumous rights of publicity and other important celebrity rights are recognized. So if you are domiciled there during your death, it's definitely going to be part of your planning. The third symptom, the Screen Actors Guild is very cognizant of it, has been increasing attention of a need for their protection of their rights, because if we head by a default, it might belong to a corporate entity instead of the star, right? So consider, and I say that because let's say you're a star, you're a music talent or an actor who has been represented by an agent in what they like to call a 360 agreement. So a 360 agreement is essentially they own all your rights. They own it and they're paying you handsomely. And this applies past death. So once you die, your interests are actually let's say you die intestate and nothing else is written, this contract might be operative and might transfer all of those interests over to an entity, and you lose complete control over your image rights, your songs, all of it and the like. So within the entertainment industry and beyond, we're seeing that numerous measures are being made to protect a person's rights. So testators, mainly celebrities who are having a planned death, let's say through old age and the like, speaking with their wills and trust attorneys, they create detailed structures of managing this. And it comes down to their personal preference. It comes down to whether they want to sell it, make a lot of money for the family, or they want to maintain the artistic integrity, perhaps be more reserved, and the like. So the law is implicitly supporting that, as we're seeing a trend of these sort of legislations growing through the US. So on the federal level, you have the Copyright Act, and the trademarks are recognized at a federal level under the Lanham Act. Section 43A protects against false endorsements. Meanwhile, if we look at publicity and personal data, those are getting state by state recognition for after death protections. So what are the ramifications of this? The first one is a very simple thing. They are removing the personal service contracts. What does that mean? The rule of thumb when you pass away is that your obligations pass away with you. No, sorry, let me rephrase that. The rule of thumb when you pass away is that your liabilities follow you unless they were of a personal service nature. So, what does that mean? If you pass away and you have numerous debts to numerous people, that would be an enforceable contract after you died, and it transfers to your heirs unless you expressly contract around it. But if it's of a personal service, let's say the year is 1960, you're an actor with a contract with a production agency, and you pass away, this contractual obligation won't be enforced against your estate because you have passed away and it was of a personal nature. Only you could have done that job. Only you are the right person for that job. Now, the beauty of this technology, or the bane of this technology, is that they are removing this element. Essentially, now just the cash, you can use the image of the actor obtained through legal means, let's say through a consent given before death or through his estate's permission. And what happens is that the production agency essentially shifts the burden. They shift the risk. They shift that risk from the actor onto them. And this is a very, very strange phenomenon now, which is going to happen in the movie industry, which is that the strange phenomenon is that the movie studios are essentially saying, look, we will be the ones completely bearing the bane or the pain of the performance, right? And the actor, we just need your rights. You don't need to do anything. You don't need to act. You don't need to do anything. You just need to show up, give us your rights, or give us your deceased family members' rights, and we'll take it over from there. So that's the first major shift we're seeing. It goes without saying, you need to kind of protect these rights better. In America, it's a state by state protection. It would be a lot better if we get a federal level of protection. Similarly, now I have been conspicuously absent about India when it comes to rights of publicity, personal data, and the like, because India has not addressed a lot of these issues yet in their jurisprudence or in the legislation. Rights of publicity in India are famously unlegislated. So these are issues which can definitely impact Indians if they're unlegislated, especially considering our long wait times in the judicial sector in India. There's a lot of scope of abuse because one can start acting as an interloper on a celebrity's, passed away celebrity's rights for years before you get an injunction to stop it. Then estate planning is an absolute. So Robin Williams has placed a 30-year prohibition against using his face and image after his death, and has given control completely to a nonprofit. So this is kind of his way of telling the industry, it is my freedom of testation, it is my will that I do not want to exist after death. So you can do that, or you can do an alternative way where you want it to be sold, where you want it to be of X quality. But how do you do this? This is opening a can of worms. So if you provide permission to say that I will allow my posthumous rights, namely your right of publicity and personal data, from being exploited, how do you regulate it? You need to give detailed instructions to your agent, to your manager, or whoever you want to act as your proxy decision maker in this circumstance. What do I mean by detailed instructions? It can cover everything. And it comes down to an industry specific thing, right? Let's stick to actors because that seems to be the easiest one. Let's say no nudity, for example, no sponsorship of sinful goods like alcohol or cigarettes, no playing controversial characters like bigots. So once you dive in, there's numerous ways to pull it apart and to look at how to control the various aspects of how one's posthumous copy is presented. Now, as I go into the end of this presentation, I don't want to overload you with information because I feel like I'm kind of throwing everything on you. So I want to leave everybody with an idea of a thought, like how would you like to see the future of these technologies play out? Because there is a possibility of two options, right? Or there's numerous, but for the purposes of this discussion, let's keep it to a dichotomy. We can live sort of in the world where one's persona, name, your creations, your personal data, all of which is considered as your property interest. You can give it to whoever when you pass away, and they can sell it to whoever. And consider this in the case of, let's say, a prisoner on death row who wants to provide for his family, and he sells away all of his digital image rights, let's call them collectively his posthumous rights. And in doing so, he gets a large amount of consideration, but it's gone. That was his last piece of his human legacy. He wanted to give it away. Maybe that is the way to go. It's a mode which supports individualism. It supports freedom of testation. However, it is a slippery slope, right? Once you start, who is to say that one entity won't warehouse every single image that ever exists in a famous capacity and now owns it? This is a legitimate danger that exists if there's an entity holding a large amount of IP portfolios and have exclusive rights to it. Let's say every single celebrity over the next 20 years bundles all of his rights, considers them as properties in a jurisdiction where it's property, and what he does is he signs them away. And in signing them away, he signs them away with an exclusivity clause in the license, which prevents it from being used from anybody else. The whole problem's over. It's all owned by a single entity. So this is a legitimate danger we have to be considering. It is, however, highly possible in the United States. Now, a trend in the United States that is significantly present is if an intangible asset is of value, it will be recognized. So, for example, posthumous defamation is often not recognized as a legal right because it's purely emotional. Invasion of privacy is not recognized after death because it's purely emotional, the harm you have. However, rights of publicity was recognized early as a legal action and recognized early to exist after death. The same with copyright, the same with trademark and other valuable sort of assets that a person creates. So this is likely to exist in the US because when it has value, they recognize it first under the law in terms of as a redressable legal action, and also under the, and also in terms of the alienability and the posthumous protections that you have. What is the second option of the economy? This is the one I feel like India might slip into because there's very similar echoes. India is not as capitalistic as the US. It has a sort of mixed economy where either the courts or the state won't allow wanton evilness. Usually the problems in our society are caused by stupidity, but it's not caused by deliberate evil, or through money making evil. It really comes down to how tightly does the state want to control this process? So in the EU, instead of having rights of publicity, they have a combination of rights of personality, which encompasses one's religion, no, not religion, sorry, reputation, privacy, and reputation, privacy, and image as one. And in a case where one's reputation conflicts with, let's say, a freedom of expression or artistic directives, what happens is that dignity prevails. This is common in Germany. There's two cases of notes, which is the Memphisito case, and there is the Princess von Hanover case, Caroline von Hanover case, both of which established it kind of links one's personality to their moral rights. It's more human centric, it gives, if let's say, for example, we take a deceased star and we place them as a clown in a movie. They're the comedic relief. They're more of the fool of the entire movie. In such a case, if you apply the German rights of personality and a system of moral rights to it, what happens is that a dignity tiebreaker will prevail. So if it's undignified, if the person's not being treated well, then we can see that the estate's wishes, or it can be stopped or enjoined. There's many other ways of which how this can be stopped. So with that said, I would just like to kind of leave everybody with the thoughts of how we can best protect this. The first would be, especially in India where this is pretty unlegislated, the first would be that we have to recognize in some form or the other posthumous protections for right of publicity and personal data. Now, personal data can be covered by e-wills, which are gaining significant importance in India. However, it needs to be legislated, at least to the extent where it emanates the legislations which have been enacted in the US, namely the idea of data fiduciaries and digital assets. So what does it mean? Your personal data transforms into digital assets, right? Upon your death, your personal data becomes a digital asset and it goes to the fiduciary of your choice. So India needs to adopt legislations like this. There's a uniform legislation which has been enacted on a state-by-state level in the United States. I feel like that would be of great benefit for India. Second, recognizing some interest in one's posthumous right of publicity. Right now, India has not dived into posthumous rights of publicity, at least insofar that movies and films are concerned. However, you never know. Tomorrow could be the day. And though India is a cautious country which utilizes disclaimers and errs on the safe side, it's still, you could never be sure. Interlopers can take advantage at any time. With that, I would just like to leave you with my last favorite quote, which is from a TV show called BoJack Horseman, which is essentially what they encapsulate how an actor's job is going to be changed. They connect a scanner to an actor's face. The studio takes over. All the actor has to do is promote the movie later on a talk show. And that's essentially how fame is being reframed in our new era, especially in the era of posthumous celebrities. So I apologize if that was long and rambly. I hope you all found that very informative. I will welcome any and all questions. Thank you, and feel free to contact me if you have any future questions.
Thank you, Mr. Menon. I would again address you as Mr. Menon because you have shared your knowledge and vast amount of information with us on such a naive and contemporary topic. And you have also opened doors for our faculty colleagues as well as students to research upon a lot many issues. So, and I would want to just inform you that you did not bombard us with a lot of information because
Right.
you did retain interest of the audience because the chat box is full of questions,
Oh, good.
and I'll be taking a few of them. Yeah. So the first question is from one of our students who is pursuing IP honors year,
Mhm.
that is Hatem. He is asking that is BARF, that is binary augmented retroframing, which was yeah, which was premiered in Captain America Civil War, something which could be used in future to help out people in a therapeutic manner.
I haven't seen that movie, but let's just put it this way. All right, and I apologize for not seeing that movie. I'm pretty behind, but let's just put it this way: any sort of augmented reality which can help someone move on from a trauma, either by confronting it. You know, you can put on glasses and you're confronted with your worst fears without actually being confronted with it, or perhaps therapeutically to make, let's say, be with one's family, and being with one's deceased family member, or maybe even in an entertainment context where you live out, let's say, your dream of doing daredevil things. So any sort of augmented reality which helps with that. The idea is that it's such a sensory overload, it's such a sensory, it's so similar to the real thing. I mean, I can say personally from using virtual reality for a simple zombie shooting game that it alters your perception, and I feel like that can definitely be used for therapeutic purposes. So considering a safe guess that that the movie uses a more futuristic perfected version of technology, there's no doubt it can be used for therapeutic purposes.
Yeah. Another question is from one of my faculty colleague and a senior faculty here, Dr. Anand Kumar. He says that on one side, you are talking about giving personhood to artificial intelligence based on robotics or animations. And on the other side, by way of reanimation technology, you are talking about interfering with the personality of a deceased person. So the question is, why such dichotomy? The second question is, will reanimation graphic will be recognized with the personhood of the deceased person, or will it have altogether a new personhood?
That's an excellent question, Doctor. The dichotomy exists because there is an exact dichotomy in the law, because it is at such a stage. Let's say, so I would say the difference maker for us to cross the object person line from an object, let's say a hologram, is essentially, for all intents and purposes, an object, to crossing into a person, it's intelligence. And here's the biggest issue: we are yet to find concrete tests for intelligence. So some people say it involves some writers say that you should test the abstract reasoning of the technological being. Others say that you have to test it like you created graded tests. So it's very hard to determine when you should cross that line. And I agree with you. There's an absolute dichotomy because how do you reconcile it? Let's say we take Microsoft's patent in a chat box, in a chatbot. That becomes highly intelligent. When you chat with it, it feels like you're chatting with your passed away family member. At what point do you say that it should be given that sort of change, that step into becoming a person? And can you repeat the first question again, please, Taruna, Professor?
Yeah, yeah. So the first question was with respect to why such dichotomy. The second
Mhm.
question is, will reanimated graphic will be recognized with the personhood of the deceased person, or will it have altogether a new personhood?
Excellent question. So that is actually, so that comes down to the question of, do we extend or change the existing standards for legal death, right? Do we extend or change it? So legal death is a moment in time, right? It's either complete cessation of the heart or brain, comes down to the doctor's judgment. So let's say a person can be cryonically restored. Do we change it? Do they come back? That's exactly why cryonics is such a fascinating topic. Let's say the reanimation works perfectly. Does the person come back as that person, or do we give them a separate legal status as a sort of cryonics patient number 247? Or do we make an AI being a legal personality like a corporation? Each question of these is it just goes into a complete mire of debate. It just never stops, doctor. And I wish I could encapsulate further, but I feel like if I just start, it's not going to stop, because on each level of this, whether you're talking about a transition from intelligence into a person, and then further from that, what is the identification to the personhood? What is the identity we assign to that? So if we make a hologram of Sri Mahatma Gandhi, we identify with him, right? That's him. But if the UNESCO did not have the, let's say, the permission of India, they would be prohibited from doing so under the Emblems and Emblems and Names Acts, I think, Prevention of Misuse 1950. So it just keeps going, right? So whose personality does Mahatma Gandhi belong to? Does it belong to India, or does it belong to him? So I wish I had a simpler answer, but I'd say that the split, it's deliberate.
Another question is from Professor Stephen. He starts his question by appreciating your session, and he says that an excellent presentation.
Thank you, Steve.
Pardon the overused glitch, but this is truly cutting edge and scary stuff. As technologies progress at an unfathomable and, for me, unimaginable rate, I assume there will be an increased market demand for descendants and their estates to exploit post death opportunities. So, this is his observation, and which follows the first question. The first question is: do you believe that these market opportunities will grow with technology? You answer the first question, then I'll pose the second one.
Okay. Yes, Steve, actually, by virtue, so there is a very nascent but booming digital afterlife industry. And this is, you can find it on major social media operators like Facebook, Google, and the like. So the digital afterlife industry is founded on this premise that when a person dies, their data is held by these entities. And what do they do with it, right? Like, they have it, and it only makes sense to commercially exploit it, right? It only makes sense. It's an asset that they have. Might as well exploit it, start creating chatbots, start selling that data. And that is why we're seeing, especially in the US, under the Uniform Fiduciary Access to Digital Assets Account Act or something like that, which has been applied in pretty much every state. uh, what we're seeing is that there's the appointment of what we call data fiduciaries, essentially a family member who can talk to the social media operators and say, please delete or memorialize their data. Now, like you said, there is going to be a lot of people who I feel will find the commercial benefit in exploiting it. So I do feel like it will be going up in terms of marketability. It just makes sense, right? Especially, it's easy money for the estate. It's easy money for your loved ones to be taken care of. But, careful with the conditions that you put on it, because you never know. What's the second question?
Yeah, in the second question, just to simplify the question, he has used a hypothetical situation wherein he says that, for example, a former president, Donald Trump, passes away 15 years from now. Now, presidential candidate Ivanka Trump, to whom Donald Trump's rights have vested in some legal capacity, has her deceased father appear in political ads and perhaps even in a live talk show. So here's the question: do you think that government regulators are anticipating these kinds of scenarios? And it seems this would also raise some constitutional law issues. Although Ivanka is protected as a life person and owns her descendant father's rights, do you think that Donald Trump's First Amendment, that is freedom of speech, right, vests with Ivanka in this situation?
So Pranav, please forgive my worst nightmare.
No,
Yeah.
Steve. I think it has attention, but only in the places where it matters. So, like if it's an obscure state where right of publicity is not heavily exploited, it doesn't have much attention. So on a federal level, it doesn't. I'm like it's not of too much importance. There's other things going on at the federal level. Even though many academics have called for right of publicity regulation at a federal level, it has not happened. However, on a state level, it comes down to where exactly you're located. California, very important. The government's not involved, but the legislation exists to sort of bolster the celebrities' protection. And if you look at Indiana, where it's like it goes on, there's no term defined, right? In those cases, then the problem becomes is that it's completely owned by the managing entity, and that's the issue here. The exploitation of these rights have not gotten to a point where government regulation is necessary. It's getting to a point where contractual and legislative oversight is necessary, but it hasn't gone to a point where, for example, in Italy they have a agency which protects the reputation of dead people. They actively try to protect that. So it hasn't gone to that point, especially in America, where regulation is kind of like less appreciated, you know. And with regard to the constitutional ideals, there have been a lot of writers who have discussed the possibility of applying the transformative test of fair use in copyright to one's right of publicity, you know. And there are some interesting proposals, but you're right. We're seeing kind of a combination of freedom of speech, the right of privacy, right, and also the right of one to maintain a decent reputation. It comes down to which country you're in, whether or not that's read into being a fundamental right. We're seeing a lot of mix into all this. And here we're having a mix of both posthumous and living interests, right? So which should prevail? It really, it's anybody's guess, you know. I hope that answered it. Yeah.
Yeah. So the because of the paucity of time, this is going to be the last question, and it's again from one of my faculty colleague, Dr.
Hmm.
Vikas Upadhyay. So it's firstly an appreciation, then a question, followed with a request from his
Okay.
end. So he says, in your appreciation, that thank you, sir. It was very good presentation and with a new area for research.
Thank you so
The
much.
question is, as issues on reanimation technology is very gray area, what can be done to avoid commercial exploitation in the present digital era and with integrity of the person is also contractualist is a remedy where they can balance between commercial use and integrity. So what is your view on the same? And his request is if you can share some literature on this issue for a more better understanding and further research upon the same.
Sure. Just repeat the first part of the question again. What can be done to protect these interests, right?
Yes, what can
Prevent
be
commercial
done to,
exploitation.
yes, yes.
Right. Absolutely. Doctor, thank you so much for your question. I would like to just go back to this slide because I would say that what we should do on our end to make sure that our eternal personality is not commercially exploited, I would say, is first and foremost, place covenants in your will, last will and testimony and other testamentary documents, that a prohibition against exploitation, if exploitation is unpalatable to you, you know, put a prohibition in very clear words that no matter what the technology, no matter what the situation, I would like my right of publicity not to be exploited under any circumstance. Okay. And again, this is a matter of personal choice. The second thing I would say that would be exercising your freedom of testation to a large extent. The second thing I would say is exercise your moral rights in your copyright. Now, one thing a lot of people do to weaponize copyright to protect their privacy is one thing people can do to weaponize copyright is this is what Jackie Kennedy Onassis did with John F. Kennedy's own private life. She used his copyrighted letters and all of the copyrighted material that he had, which related to his private life, and she protected it under copyright, thereby protecting privacy instead of going for the protection of privacy directly. You get it? So that would be one way. So if you have a copyright, use that to protect your privacy. That would be the first layer. Second layer would be to exercise your moral rights and to authorize your state to exercise your moral rights if it's permissible under the legislation where you're registered. So this would be, I would say, the biggest ones. The second thing is on a personal data level. If by chance the law recognizes the idea of personal data or digital assets, direct your estate executor to conduct erasure requests, rectification requests, get your data cleaned off the internet. You get it? So it can never be exploited in that manner. Then so you have to shore up everything on the anti-mortem end with regard to the more nuanced aspects like one's artistic integrity, future business dealings, possibly your licensing rules, your things of personal taste and preference, advanced directives. You need to have an advanced directive. I think I wrote it here, the last point. So essentially you crystallize all of your interests in your reputation in an advance directive, and then you ask a proxy, right? You ask whoever you appoint as your estate executor to execute these artistic directives. Now, let's say hypothetically you're a celebrity, or let's say hypothetically you're a businessman who's famous, right? Or it can be anybody who is of note. You hire an executor who thinks like you, who worked with you, who has that same frame of mind. And essentially they should be used to your business dealings, artistic preferences, and the like. And in doing so, you are doing as close as you can on your end to have a reasonable representative in the afterlife. Now, as for literature, I would say with regard to US law, I would look at Joseph J. Beard's work. Professor Joseph J. Beard. He is excellent. He has written two very, very exhaustive pieces on the idea of posthumous existence. One is called Clones, Bones, and Twilight Zones, and the other one is called Casting Call at Dawn. And he breaks it down very masterfully. And also, it just comes down to your personal preference, Professor, Doctor. Please feel free to contact me, mail me, and I'd be happy to just give you everything I have, because I have so much that I could share with you. So I'd be happy to. Thank you.
Yeah. So with this note, I would extend my heartfelt gratitude on behalf of the Institute and on my personal behalf to Mr. Pranav Menon for sparing some time for us from his busy schedule and sharing his thoughts on this wonderful topic and provoking thoughts in our mind for further researching upon the same. And over to you, ma'am.
Yeah, Pranav, it's an amazing presentation. Oh God, I mean, while you were making a presentation, there were so many issues that crop up in mind. I mean, I think this is the whole new world which is evolving, and it looks a little scary as well. So congratulations. I mean, you have been researching on this area, which is really great. So congratulations to your supervisor, Penn State Law, and we really look forward to your thesis and your further research on this. Thank you, Pranav.
Thank you. May I just say thank you so much for hosting me, Doctor, and thank you all for being so receptive, so kind, and very encouraging. It's going to be tough to finish it, but I'm so glad I had such a captive audience. And I really thank Nirma Law University for especially just letting me present. It's great to get the topic out there. Thank you.
Thank you.
Yeah. Now I would like to invite our student representative, Ms. Eshani Kothari, to deliver the vote of thanks.
You may stop sharing the screen. Yeah.
Oh, yeah.
Hello and good evening to one and all. Friends, it's a matter of immense pride and privilege for me to propose the vote of thanks on this momentous occasion. It is very well said that success is not final, failure is not fatal. It is the courage to continue that really matters. And it was an absolute privilege to host an epitome of persistence and courage today. On behalf of Institute of Law Nirma University, I wholeheartedly thank Mr. Pranav Menon for accepting our invitation and for delivering such an insightful session on the reanimation technology and its impact on the descendants. I would also like to express my gratitude towards our Reverend Dean and Director at Institute of Law, Professor Dr. Purvi Pokhriyal, for organizing the International Teaching Month for the students so that they can have a global insight towards various trending legal issues. I would also like to acknowledge the presence and the participation of Professor Stephen Barnes. Thank you so much, sir. Thank you so much, Taruna ma'am, for being the moderator for today's event and for the smooth flow of this virtual webinar. No event is complete without the never-ending support of the technical and the support staff. I take this opportunity to thank Gagandeep sir, Feya sir, Dikan bhai, Shreya ma'am, and everyone at Nirma University for their constant support and guidance. Last but not the least, a big thank you to all the reverend professors and the students for their active participation and patient listening throughout the event. Thank you, one and all.
Thank you, Eshani. And with this note, I wish a very good day ahead to Professor Steve and Mr. Pranav. And
Thank you
with
so
this,
much,
we
everybody.
end our today's session. Thank you once again.
Thank you.
Please feel free to contact me, everybody. Thank you. Goodbye.
Thank you.